the matter of JH and FW Green Ltd and On Tower UK Ltd.
Mr. Claimant.
My lords, my lady, on this appeal I appear with my friend Mr. Wayne Clark for the appellant, JH and FW Green Ltd, and my friends Mr. Oliver Radley Gardner, Queen's Counsel, and Mr. Justin Kitson appear for the respondent, On Tower UK Ltd, as is its current name anyway. This is an appeal from a decision of the Upper Tribunal Lands Chamber given on the 15th of December last year, with the permission of the tribunal itself granted on the 25th of January this year. The proceedings, as the court will have seen, are an application by On Tower for a new code agreement under Part 5 of the Electronic Communications Code, which is Schedule 3A to the Communications Act 2003, added by the Digital Economy Act 2017 to replace an old code, which has now been superseded, therefore. And what is in dispute appears to be quite a narrow issue, namely the proper ambit of rights of upgrading and sharing of electronic communications equipment in the new agreement. But as the court, I hope, will have seen, there are a number of points of principle and procedure under the new code which have to be understood and resolved in order to get to the right answer. The basic facts are the original lease was granted on the 12th of November 1999 for a term of 20 years from the 17th of March 1999. So the original lease expired at the end of the 16th of March 2019. The original tenant had assigned the term to On Tower in 2000, but the parties have otherwise remained the same for 20 years and so. The lease was contracted out of security of tenure under the Landlord and Tenant Act 1954 and was consequently under the Transitional Provisions following the Digital Economy Act 2017, a so-called subsisting agreement within the terms of paragraph 1.4 of those transitional provisions, and was continued, as we'll see, was continued by paragraph 30, subparagraph 2 of the code after its contractual expiry. It could therefore be modified or terminated and replaced under Part 5 of the code in the circumstances prescribed. And these proceedings were by On Tower Ltd, UK Ltd, to obtain a termination of the original lease, or the contractual or the statutory extension of the original lease, and an order for a new lease. As I say, the issue between the parties is as to the proper ambit of the upgrading and sharing rights, and that's explained at paragraphs 22 and 23 of our skeleton, which I hope the court's had a chance of reading.
We have all read extensively, obviously, including the skeletons and the decision, but other things as well.
I'm sure. Then I won't take too much time over it, certainly at this stage. But what On Tower wanted was to be able to install, quote, any, end quote, any electronic communications apparatus, and wanted an unrestricted right to upgrade it at any time and for any purpose. Separately, On Tower also wanted to be able to share the occupation and use of the premises and the equipment with providers of electronic communications networks, that right being without restriction. And by contrast, the appellant wanted, first, the identification of the actual equipment which was going to be installed. It was happy for rights to upgrade and share to be included, but the argument was that they should be subject to the constraints and conditions referred to in paragraph 17 of the Code. It's necessary, therefore, to consider the terms of paragraph 17 of the Code and how it should operate in the context of a renewal application. Our submission is that the Tribunal took the wrong approach, indeed, we say clearly so, to the determination of the upgrading and sharing rights. And I'll need to take the Court through the relevant parts of the Code with some care, I'm afraid, but it may be helpful. But if I'm going too slowly, I'm sure I'll be hurried up. But I hope to deal with my submissions under three heads. The first is to answer the question, what is the procedure on an application under Part 5 of the Code? And what is the approach that has to be taken by the Court to determining any terms in dispute? And in that section, I will also take in how paragraph 17 affects the position in that context.
Do you mean to say court or tribunal?
It is court or tribunal, indeed. In this instance, it's tribunal, but I think throughout the Code, the word court is used, which is then defined to mean court or tribunal.
I mean, I've noticed that the Code always refers to court, whereas actually everything goes to the tribunal, and yes. I assume you're right that there is somewhere a definition.
That's right. I can't remember offhand where it is, but yeah. Yes, sorry, it's by regulation rather than in the Code.
Yes, I see.
So I'll take in paragraph 17, but I also want to take the Court to Part 4 of the Code to contrast that with Part 5, because as your Lordships and your Ladyship will have seen, what happened here was that the Tribunal proceeded as if it were a Part 4 application and seems to have applied Part 4 reasoning, whereas it should have been considering Part 5 and applying Part 5 reasoning. So that's the first section of my submissions, and that's the longest part of it. The second is to take your Lordships and your Ladyship to the judgment of the Tribunal and show how it went wrong and applied the wrong approach. And then, as my third head, I would submit what the Tribunal should have done on the material before it and the conclusion that it should have reached. Now, when it gets to that third stage, I recognise that if the Court accepts the submission that the Tribunal applied the wrong test, then it is open to this Court to send the case back to the Tribunal for reconsideration on the proper footing. And I've included that in our appellant's notice. For your note, I'm not sure I need to go there, but I have an alternative form of order, page 6 of the core bundle, which allows the case to be remitted. But as the Court will have seen, our primary position is that the Court can now act to determine the outcome, principally on the footing that On Tower put forward no real case or evidence upon which it would be appropriate to override the provisions for upgrading and sharing set out in paragraph 17. So with that as the overview of where I'm going with my argument, I start first with my first set of submissions under the heading The Correct Procedure. And as I've indicated, it's important to draw the distinction between two quite separate types of situation where the Court or Tribunal is called upon to define and impose the terms of an agreement to govern the parties' relations with each other. And they are Part 4, which is the imposition of a new agreement, that is to say, where no agreement existed before. And then Part 5, which is the modification or the termination and replacement of an existing agreement that has already taken place between the parties. That may be an agreement that's been reached voluntarily, as in this case, or it may be an agreement that's already been imposed under Part 4. To make the obvious point at the outset, these are quite different situations for which the Code has provided quite separate procedures under Parts 4 and 5 respectively. And they are not to be confused. There's a large overlap in the considerations which the court or tribunal is enjoined to take into consideration. But equally, there are important differences. So if I could go to the Code, in the authorities bundle, you'll find that behind tab 13. Now just pausing, there was a difficulty with the photocopying of tab 13, and each of your lordships and your ladyship should have received a replacement tab 13 yesterday.
I certainly did.
Yep.
I hope others did.
Can I just check?
I think so. I mean,
Yes.
what I've got looks about right. So
All right, well,
What,
please.
what we originally had didn't include much of Part 4 in particular.
Exactly.
Whereas what I've got now does include Part
Yes.
4, and I assume others also have
Yes.
Part 4.
I've got the amended lot.
Yeah.
That's good. Well, let me see how we go, and if my Lady Justice Whipple is
I'll let you know
concerned,
if
you'll
I'm.
let me
I
know.
think I'm okay, but I'll let you know
Thank
if
you.
that changes.
Now, starting with paragraph 3, the Code starts with a number of definitions to set the scene, and one of them in paragraph 3 is what is a code right. And the code right is, in relation to an operator and any land, is a right for the statutory purposes, A, to install electronic communications apparatus on, under, or over the land, B, to keep installed electronic communications apparatus which is on, under, or over the land, C, to inspect, maintain, adjust, alter, repair, upgrade, or operate electronic communications apparatus which is on, under, or over the land, and then a number of other rights which I needn't go to. But you'll see there that the electronic communications apparatus is can be installed pursuant to a code right, and that includes upgrading it, but there's no separate heading for a code right to exist of sharing. Now, some significance was ascribed to that distinction in the judgment below, but for present purposes, it's not part of my submissions that there is any particular point that emerges for the court to consider on that observation. Then if I could jump to paragraph 8, sadly, this form of copy of the code doesn't seem to tell us when a different part commences. But paragraph 8 is the introductory to part 2. So part 2 is starting here.
You can just about work it out, I think.
Yes, exactly.
From
This
the,
part of this code. Yeah.
And if you look at the bottom, you get it says Schedule 3A Electronic Communications Code Part 2,
Yes,
but
Part
that doesn't
2.
tell you that paragraph 7 is also in Part 2.
Exactly. And it doesn't give you the actual title, although, of course, the title is the heading for the part. Although that's not an aid to construction, it might nevertheless be a useful guide.
I think you do get the heading. It says conferral of code rights and their exercise, which I think is the heading to Part 2, is it?
Yes, that's right. I see, yes. So that's a little bit confusing there. But anyway, on the substance of the paragraph, this part of the code makes provision about the conferral of code rights, the persons who are bound by code rights, and the exercise of code rights. And then over the page at paragraph 9, there's a provision as to who may confer code rights, and that is by an agreement between the occupier and the operator. And in paragraph 10, such an agreement between an occupier and an operator can become binding on other persons interested in the land. Now, all of that, go on to paragraph 11, requirements for the agreements and exercise of code rights. All of that shows that you can have a voluntary agreement between an occupier and an operator in relation to code rights. And as we'll see, when you get an enforced agreement or an imposed agreement, the provisions are in each case that they operate as if they were a voluntary agreement under Part 2 of the Code. Part 3 I will come back to, but Part 3 starts at paragraph 15 and includes paragraph 17, which, as I say, I'll come back to, but that is the power for the operator to upgrade or share apparatus. And we'll have to consider that in some detail later. Jumping, though, to the procedures under Part 4 and 5, Part 4 starts at 19 under the heading Power of Court to Impose Agreement. So this is for the first time, a brand new agreement. And paragraph 19 explains the ambit of this part. This part of the Code makes provision about the circumstances in which the court can impose an agreement on a person by which the person confers or is otherwise bound by a code right. Secondly, the test to be applied by the court in deciding whether to impose such an agreement. Thirdly, the effect of such an agreement and its terms. And fourthly, the imposition of an agreement on a person on an interim or temporary basis. So those are, I'm not going to go to the interim or temporary basis paragraphs, but the first three set the scene. And paragraph 20 then starts to roll out the procedure. And under the heading, when can the court impose an agreement, the paragraph continues. This paragraph applies where the operator requires a person to agree, A, to confer a code right on the operator, or B, to be otherwise bound by a code right which is exercisable by the operator. So reflecting paragraph 9, the occupier granting the right, and paragraph 10, other people being bound by the right so granted. And then the procedure is that the operator may give the relevant person a notice in writing, setting out the code right and all of the other terms of the agreement that the operator seeks, and stating that the operator seeks the person's agreement to those terms. And then if they don't reach an agreement before the end of 28 days, you can make an application. And then 4, subparagraph 4, an order under this paragraph is one which imposes on the operator and the relevant person an agreement between them which confers the right, the code right on the operator, or provides for the code right to bind the relevant person. Now, I just pause to ask your Lordship and your Ladyship to note that what is in issue is therefore what the operator seeks. The operator sets out all the terms that it is seeking in its notice and is seeking the person's agreement to those terms. And so the discussion which then takes place when it gets to the court or tribunal is that is as to the terms that have been proposed by an operator. And the next paragraph, paragraph 21, deals with the test which is to be applied by the court, and that is subject to paragraph 5, subparagraph 5. The court may make an order under paragraph 20 if and only if the court thinks that both of the following conditions are met. The first condition is that the prejudice caused to the relevant person by the order is capable of being adequately compensated by money. And the second condition is that the public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. In deciding whether the second condition is met, the court must have regard to the public interest in access to a choice of high-quality electronic communications services. And then 5, the court may not make an order if it thinks that the relevant person intends to redevelop all or part of the land to which the code right would relate or any neighbouring land, and could not reasonably do so if the order were made. So there are some, as it were, threshold conditions which need to be demonstrated and complied with, and they are that the prejudice is compensatable in money, and that there is public benefit which is likely to result from the making of the order, which outweighs the prejudice to the landowner. And then on paragraph 22, we see that an agreement imposed by an order under paragraph 20 takes effect for all purposes of this code as an agreement under part 2. So it's as if it was a voluntary agreement struck between the parties. And then paragraph 23 picks up the question of the test or the approach of the court to the terms of the agreement. And what is provided is that an order under paragraph 20 may impose an agreement which gives effect to the code right sought by the operator with such modifications as the court thinks appropriate. So again, picking up the point I made before, the argument is set, or the parameters of the argument are set by what the operator seeks. And here, the court is considering whether to impose an agreement which gives effect to the code right sought by the operator, but the court is concerned to see whether any modifications are needed as the court thinks appropriate. And then for the rest of this paragraph, there are aspects of that consideration which are then set out. 2 says that the agreement is to contain such terms as the court thinks appropriate, subject to paragraphs 3 to 8. 3 and 4 are about consideration payable. 5 is about ensuring that the least possible loss and damage is caused by the exercise of the code right to persons who occupy the land, own interests in the land, or are from time to time on the land. Clearly an important provision, least possible loss and damage. And 6 supplements that by saying this applies to a person regardless of whether the person is a party to the agreement. And then 7 and 8 are about duration of the code right and whether or not it is determinable at any stage. So those are the considerations set by part 4. You have the 2 threshold considerations at the start, which is compensatable, prejudice is compensatable in money, and that there is a public benefit that overrides any prejudice to anybody. And then the specific heads of terms, they are to be such as the court thinks appropriate, including modifications to what is sought by the operator, and in particular under the headings consideration, duration, determination, and so forth, and in particular the least possible loss and damage, the court will make its determination. Then 24 I needn't go to, or 25, these are about consideration and compensation. So possibly just to note that part of the purpose of the code is to reduce the amounts that could be charged by a landowner for electronic communications apparatus on its land. I say landowner, occupier is the word used.
Because you have a no scheme assumption.
That's right. The no network assumption
No network
is the
Yes.
phrase I think most people use. But that's right, exactly so. So you reduce the market value by reducing one of the assumptions that otherwise used to apply. And that has reduced considerably the money payable to an occupier.
Yes.
Then I needn't go to 26 and 27, which are about the interim and temporary code rights. And I'll go on to paragraph 28, which is the introduction to part 5, which is dealing with the separate situation. This part of this code makes provision about the continuation of code rights after the time at which they cease to be exercisable under the agreement, the procedure for bringing an agreement to an end, the procedure for changing an agreement relating to code rights, and the arrangements for making of payments under the agreement while disputes under this part are resolved. And paragraph 29 states at the outset that this part of this code applies to an agreement under part 2 of this code, subject to paragraphs 2 to 4, which I don't think I need to go to. But there is the provision which says it applies to part 2 agreements. That means either one which was a voluntary agreement under part 2 at the outset, or was an imposed agreement under paragraph 20 and 21, but becomes a part 2, or is to be treated as a part 2 agreement by reference to the provision that we've seen, paragraph 22. And the first thing it does, this part, is paragraph 30, is to continue code rights. So subparagraph 2 applies if a code right is conferred by or is otherwise binding on a person, the site provider, as the result of a code agreement. And under the terms of the agreement, the right ceases to be exercisable, or the site provider ceases to be bound by it, or the site provider may bring the code agreement to an end so far as it relates to that right. Where the subparagraph applies, the code agreement continues so that the operator may continue to exercise that right, and the site provider continues to be bound by the right.
Just so we're clear, have we had a definition of code agreement? Or does that come much later?
29.5, I think.
29.5.
It's an agreement to which Part 5 applies.
Yes.
Yeah.
The previous page. I should perhaps have taken that. So the first is that you continue it, and then there are a series of provisions about how you bring it to an end, therefore. If it's being continued under the code, how do you bring it to an end? The first provision of that kind is paragraph 31, which applies to a site provider being able to bring the agreement to an end by giving notice in accordance with this paragraph to the operator, and the notice must do certain things, but in particular state the ground on which the site provider proposes to bring the code agreement to an end.
And just being pernickety again, have we had a definition of site provider? We had occupiers earlier.
Yes, site providers. The previous page, paragraph 30, subparagraph 1a, is a code right is conferred by or is otherwise binding on a person, the site provider, as the result of a code agreement.
Yes.
So that's the definition of site provider for the purposes of this part.
Yeah.
So where you have a site provider who is a party to a code agreement, sorry, just pausing there. The agreement or the original agreement was granted or imposed upon an occupier, because only an occupier can grant code rights. That's paragraph 9. But there may be a difficulty, and it's emerged in some of the cases on this, there may be a difficulty later if you want to reach some new agreement because that person, the original occupier, probably isn't in occupation anymore of the relevant parcel of land. It might have granted a lease of it, it might have no rights in respect of it. The electronic communications equipment might be the only thing in occupation of that piece of land. So it is of importance. It's been considered by this court, indeed, as of importance that the nomenclature changes at this point to site provider rather than occupier. But it can be, as it were, the original occupier who is now the site provider.
Yes.
So 31, we don't need to dwell on, but it's a way for the site provider to bring the code agreement to an end. He states a ground on which the site provider proposes to bring the code agreement to an end, and then the site provider, after the end of the period of 18 months from the notice, is able to bring some proceedings. And the grounds are stated at subparagraph 4, and they are substantial breaches by the operator of its obligations, persistent delays by the operator in making payments under the agreement, intention to redevelop the land or any neighbouring land, and could not reasonably do so unless the code agreement comes to an end. And then D is the operator is not entitled to the code agreement because the test under paragraph 21 for the imposition of the agreement on the site provider is not met. So if there ceases to be one of the threshold requirements for the continuation, then the site provider can complain about it and bring the agreement to an end. Now, we're not concerned in this case with the site provider drawing the code agreement to an end. We're looking at the operator. So I don't think I need to go to paragraph 32. That just provides for counter notice by the operator to a notice by the site provider. And what's more important for our purposes is paragraph 33. Under the heading, how may a party to a code agreement require a change to the terms of an agreement which has expired, meaning contractually expired or expired in accordance with its terms. An operator or site provider, so both sides now, who is a party to the code agreement by which a code right is conferred by or otherwise binds the site provider, may, by notice in accordance with this paragraph, require the other party to the agreement to agree that the agreement should have effect with modified terms. Or B, where the code agreement, under the code agreement, more than one code right is conferred by or otherwise binds the site provider, that the agreement should no longer provide for an existing code right to be conferred by or otherwise bind the site provider. C, the code agreement should confer an additional code right on the operator, or provide that the site provider is otherwise bound by an additional code right. D, the existing code agreement should be terminated and a new agreement should have effect between the parties which confers a code right on the operator or provides for a code right to bind the site provider. So a number of situations, the particular application or notice and then application that we're concerned with is D here, in that On Tower was looking for the existing code agreement to be terminated and a new agreement to have effect between the parties, which confers a code right on the operator. And then there are provisions as to the notice, which must essentially set out what it is you want, and it must also specify the day from which it is proposed that the modified terms should have effect, or other relevant days, depending on what the choice is. And the day, over the page at subparagraph 3, the day specified must be after the end of 6 months beginning with the day on which the notice is given. And after the time at which the code right to which the existing code agreement relates would have ceased to be exercisable, apart from paragraph 30. So it's after your contractual expiry, or the date that you're suggesting must be after your contractual expiry, even though the rights are still being continued because paragraph 30 says they are to be continued. And then 5, so this is 33(5), is the right to bring an application. And that says where this paragraph applies, the operator or the site provider may apply to the court for the court to make an order under paragraph 34. And then paragraph 34 is the provision which tells you what the approach is to be on such an application under 33(5. Or indeed under 32, but we're not concerned with 32. And paragraph 34 starts with setting the context. This paragraph sets out the orders that the court may make on an application under paragraph 32 or 33(5. And they are as follows. First, these are the orders that can be made. Subparagraph 2, the court may order that the operator may continue to exercise the existing code right in accordance with the existing code agreement for such period as may be specified in the order. And then the next possibility is at 3, the court may order the modification of the terms of the code agreement relating to the existing code right. 4, where the code agreement, under the code agreement, more than one code right is conferred by or otherwise binds the site provider, the court may order the modification of the terms of the code agreement so that it no longer provides for an existing code right to be conferred by or otherwise bind the site provider. 5, the court may order the terms of the code agreement relating to the existing code right to be modified so that it confers an additional right on the operator or binding the site provider. And 6 is the one we're concerned with here, which is the court may order the termination of the code agreement relating to the existing code right and order the operator and the site provider to enter into a new agreement which confers a code right on the operator or provides for a code right to bind the site provider. So that's the, as it were, the menu of options that are available for the court. Those are the orders that the court can make. And then some provisions about the effect. 7, the existing code agreement continues until the new agreement takes effect. 8, which is a similar provision we've seen before to the Part 4 agreements. 8 says this code applies to the new agreement as if it were an agreement under Part 2 of this code. So the new agreement is a Part 2 agreement and therefore itself can be renewed in due course when it comes to an end. And then we need to pay attention to the next few paragraphs. The terms conferring or providing for an additional code right under paragraph 5 and the terms of a new agreement under subparagraph 6 are to be such as are agreed between the operator and the site provider. 10, if the operator and the site provider are unable to agree the terms, the court must, on an application by either party, make an order specifying those terms. And then some of the provisions that we've seen in Part 4, but not all of them, are applied expressly by paragraph 11. And the paragraphs 23, 2 to 8, 24, 25, and 84 apply to an order under subparagraph 3, 4, 5, so far as it modifies or specifies the terms of the agreement, and to an order under subparagraph 10. So just following that through, we are an order under subparagraph 10 because the court will have the responsibility of specifying the terms which have been unable to be agreed between the parties. And those paragraphs apply as they apply to an order under paragraph 20. And then also dealing with subparagraph 10, so the court setting the terms, in the case of an order under subparagraph 10, the court must also have regard to the terms of the existing code agreement. And 13, in determining which order to make under this paragraph, the court must have regard to all the circumstances of the case, and in particular to A, the operator's business and technical needs, B, the use that the site provider is making of the land to which the existing code agreement relates, C, any duties imposed on the site provider by an enactment, and D, the amount of consideration payable by the operator to the site provider under the existing code agreement. And then there are some specific provisions which I needn't deal with.
Not that it matters, I think, but I picked up from one of the Scottish cases, I think, that in relation to a carryover agreement, D didn't apply. Is that the case here?
Yes, you mean under the transitional provisions?
Yes.
Yes, that's right, yes.
Yep.
Exactly, yep. So just to flick back to have these points clearly in mind, flick back to paragraph 23 and see which of those paragraphs are to apply to a Part 5 application. They are not paragraph 23.1, so we are not dealing with giving effect to the code rights sought by the operator with such modifications as it thinks appropriate. What we are dealing with is 2, which is whatever the terms are to be whatever the court thinks appropriate, that's the word used, subject to paragraphs 3 to 8, and then we see the 3 to 8 provisions are consideration, that's 3 and 4, least possible loss and damage is 5 and 6, and then duration and determination 7 and 8. So those are specifically applied, as are 24, 25 and 84, which broadly all deal with consideration. I won't trouble the court with those.
Yeah.
Those are the key provisions of Part 5. And just standing back for a moment to compare the differences, or to compare the two procedures under Part 4 and Part 5, there are threshold questions on a Part 4 application which are not relevant to Part 5. They are the compensatable prejudice. Prejudice is compensatable. And the public benefit with the object of high quality communications service. So those questions don't apply. Secondly, paragraph 23.1 is not part of Part 5. So we're not starting from what the operator seeks.
Is that fair? Under the Part 5 procedure, the operator has to say what he requires, doesn't he?
Well,
I mean, he said under 33.1, you by notice require the other party to agree something. And then going on in 33, you have to say what you propose in terms of the new agreement and so on.
yes. But what 34 does not say is that you then take that document, as it were, as the document to be considered, and you subject it to the question of whether modification should be made to it. On the contrary, as I'll come to in a moment, 3412 tells you that the document you should be considering is the document providing for the terms of the existing agreement. Because they will remain unless there's some reason to change them.
Now, I follow the point about having regard to the existing agreement. In terms of the distinction between 23.1, which is the court has a discretion as to whether or not to impose an agreement which gives effect to the code rights sought, and on the other hand, considering in the context of 34 whether or not to exercise the power to terminate and replace in the context of an application by an operator having given notice stating what he requires and proposing terms. Is there any real difference?
Well, yes, there is, we say, on the basis of who has to make the running. So the procedure under paragraph 20, 21 and so on seems to be saying that you consider what the operator seeks, and modifications are then for somebody else, the site provider presumably, to complain about. That is the occupier at this stage. The occupier will say, well, it should be modified in the following respects. And so the argument will then be engaged around what the occupier has objected to in the terms that have been proposed by the operator. Now, the whole point in our submission about a provision like 34.12 is that you don't do that. The starting point is the terms of the existing agreement.
Well, wouldn't that be one of the bases on which the site provider objected? I mean, you're still concerned with the points of difference between the operator and the site provider, aren't you?
Of course. I mean, in a general sense, there are going to be, on each of these provisions, there are going to be competing contentions put forward. But on a narrow basis, the provision of Part 4 seems to be that the operator's, what the operator has specified is your starting point. Whereas under Part 5, the effect of 34.12 is that the starting point is not what the operator wants, but what you've got already. And that does make an effect, therefore, have an effect to what the court might want to consider and how it should approach the respective contentions of each side.
I could understand that submission if the code provided that there should be a presumption that you would continue. All it says is that the court should have regard to, and the court is, with excellent argument on both sides, going to have regard to those matters raised, which will, of course, say what was there before. So, I mean, given that it's not giving you a starting point or an ending point, it's just saying what you should have regard to.
Well, I'm going to take your lordship and your ladyship to the House of Lords Authority, which has explained what having regard to means in the context of the Landlord and Tenant Act 1954, and then I hope demonstrate to the court that this was deliberately. That type of thinking was deliberately introduced into the Part 5 procedure. And indeed, that this court, that is the English Court of Appeal, has already said as much. That the point was to introduce the 1954 Act way of thinking. And the point about the 1954 Act way of thinking is that having regard to means that that's the starting point. So you can change it if there's a reason to change it, but the consequence is that it's for the party seeking the change to demonstrate and justify the need for a change.
I mean, I follow that that's an important argument. I'm not quite sure why the omission of 23.1 matters. I mean, you pointed out that under 34 you have regard to 23.2 to 8. not to 23.1, but 23.1 seems pretty innocuous.
Well, only because, I mean, Your Lordship may think I'm seeking to derive too much from it, but if one thinks about the procedure, which means that you are looking at what the operators are seeking and subjecting it then to the question of should I modify it in some way. You end up with what the operator seeks as the starting point, and then it may be said that it's for the person proposing the modification to demonstrate that a modification is required. Now, that's what I seek to derive from it, and that is indeed, as I hope to show the court, that seems to be what happened in this case. Even though it was a Part 5 application, it was treated as a Part 4 application, where what the operator wanted was actually the starting point. And that is, as it were, the fairly fundamental basis upon which the tribunal went wrong in our submission. So just reverting to my comparison of the two procedures, as I said, there are no threshold questions in Part 5.
Yeah.
Paragraph 23(1) is not part of the process, with the consequences I've hoped to explore with Your Lordship. Paragraph 23(2) and 2 to 8 are common to both. And then the tests in paragraph 34, particularly 12 and 13, are not part of the process in Part 4. Now, this all seems rather narrow and possibly petty, but the submission I make is that this is not accidental. You could have a simplified procedure that applies to both, but it wasn't done that way. The Part 5 procedure was deliberately designed to track the kind of procedure that had worked so well in the Landlord and Tenant Act 1954 in relation to the protection of business tenancies. Your Lordship and Your Ladyship will no doubt have immediately spotted the kind of echoes or similarity in procedure between 54 Act and what we've seen in Part 5. So you start with the continuation pending something happening, and then that something happening is a notice procedure followed by an application to the court after the end of a fixed period, and the court has power to have regard to the terms of the existing tenancy and all the circumstances. Now, that last point is the point I just want to dwell on a little bit, and perhaps going to the authorities bundle, I could just take the thought to tab 12, which has in it some extracts from the Landlord and Tenant Act 1954. And on the last page of that tab, we have section 35, which says that this is under the heading of the other terms of the new tenancy. The terms of a tenancy granted by order of the court under this part of this Act, other than terms as to the duration thereof and the rent payable thereunder, dropping down a couple of lines, shall be such as may be agreed between the landlord and the tenant, or as, in default of such agreement, may be determined by the court. And in determining those terms, the court shall have regard to the terms of the current tenancy and to all relevant circumstances. So one sees the same kind of procedure. The terms are as agreed, in default of agreement, settled by the court, but having regard to the terms of the current tenancy and to all relevant circumstances. Now, the Law Commission had designed that to try and reproduce in the code the advantages that were thought to exist under the 54 Act. And
was Judge Cook the lead commissioner on this?
she was, yes, I think she was, yeah,
Yep.
indeed. And there are some relevant extracts in behind tab 14 of the authorities bundle. And if I could take the court to page 320 of the bundle, there's a page number 115, which seems to have either overlain it or underlain it, but it's paragraph 6.79, and what is said here is, we are impressed by the arguments in favour of the 1954 Act, which is well respected and whose provisions appear to operate for the most part smoothly. We're also impressed by the observations made by code operators to the effect that they would be generally supportive of a right for landowners to have the apparatus removed where they wish to redevelop the land. Accordingly, we're attracted to the idea of adapting and incorporating within the revised code the regime found in the 1954 Act, while eliminating the current dual protection. And
is there anything to be said about the current dual protection, or can we just forget about
we can
whatever
forget
that
about
was?
But that's in the old code, so
Yes,
that was being overtaken. And specifically on section 35, going ahead to page 324, paragraph 6.114, the recommendation given is, we recommend that the revised code should provide that the terms of a lease granted by order of the tribunal shall be such as may be agreed between the site provider and the code operator, or as, in default of such agreement, may be determined by the tribunal. And in determining those terms, the tribunal shall have regard to the terms of the current lease or other agreement and to all relevant circumstances. And the footnote at the bottom of the page, 57, is compare section 35. So this was a very deliberate choice of procedure. And in the authorities bundle, we have several cases which I now need to go to just to show how that affects the position. The first, which is just a short point really, under tab 4, we have a case called EE Limited and Chichester, which you'll see from the parties is to do with the Merrick estate, the trustees of the Merrick estate. And that was a case which involved the question of a site provider having an intention to develop. And so the question, this is under part 5, and so the question arises, well, what is an intention to develop? And all that I really want to get from the case, at page 451 of the report, or 55 of the authorities bundle, is the section sidelined in red, which shows that the court took pretty much wholesale from the law under the 54 Act the kind of considerations to what you need to prove to establish intention to redevelop. So the courts have already applied the idea that this was a deliberate attempt to bring in the principles of the 54 Act into the Part 5 procedure, and that they should be applied, mutatis mutandis, to the situation under Part 5.
So just looking at paragraph 38, I see in the middle, the tribunal says, clearly the code, new as it is, must be looked at with a clean slate and as a fresh start. Principles applicable to the 1954 Act should be adopted where they're relevant,
Yes,
although we're mindful of the need to be aware of the different contexts.
quite.
Then not all principles will be relevant, but you say this principle is relevant.
Exactly. And the next case is the case on which I particularly rely, which is germane to the particular point that I'm trying to make about the effect of 3412. And that is the Ashlock case, which is behind tab 9. Just to set the scene, Ashlock is a case about a subsisting code agreement under the Transitional Provisions, which had the right to renew under Part 5 as a result of the Transitional Provisions. But the operator claimed that those provisions did not exhaust its rights, and it was also able to apply for a brand new agreement, as it were, under paragraph 20, part 4 of the code. And the Court of Appeal said no. And there were two halves to the argument. One was that the occupier is the only person who can grant a right. And there was no occupier other than the operator itself at this stage. And that's what's called the Compton-Beecham. That goes back to the Cornerstone and Compton-Beecham case, which was decided in this court and is on appeal to the Supreme Court in February, I think. So that was one reason. The other reason was the interpretation of the transitional provisions. That having set out that effectively that there was a Part 5 renewal, then it would be surprising, let us say wrong, to suggest that there was a Part 4 possibility available at the same time. But for present purposes, one of the important parts of the argument related to 3412, or the effect of 3412, importing into that effect, the salient principles behind Section 35 in the 54 Act context. And we see that at paragraph 101 of the report, which is on page 234 of the bundle. And this is Lord Justice Lewison speaking. There are a number of further difficulties which would arise if an operator in the position of Cornerstone had an unfettered right either to seek the imposition of an agreement under Part 4 or to apply to renew its lease under Part 2 of the 54 Act. The Deputy President summarised them at 96. Cornerstone suggested operation of the code would be even more astonishing in the case of a subsisting agreement to which Part 2 of the 54 Act applies, which the Law Commission recommended should not obtain the benefits of the new code retrospectively. Rather than making use of the right of renewal under the 54 Act, which requires between 6 and 12 months' notice to be given under 26(2), expiring after the end of the contractual term, the operator would have unrestricted opportunity to give 28 days' notice under paragraph 20. Having done so, the operator would escape the provisions in Section 34 of the 54 Act for determining the rent under a new tenancy, which substantially replicate the open market, and would instead obtain access to the valuation assumptions in paragraph 24 of the Code, including the no network assumption, which strips out the component of value referable to the intended use of the site as part of the operator's network. The operator would also escape the restrictions of Section 34 of the 54 Act. That should be 35. and those of 3412 of the Code, both of which make the terms of the existing tenancy or code agreement the starting point, when, in default of agreement, the court or tribunal is required to fix the terms on which the new rights are to be enjoyed, citing OMA and City of London and Real Property Company. Instead, the operator would have the benefit of paragraph 23(1)(2) of the Code, which requires the tribunal to impose an agreement which gives effect to the code rights sought by the operator, with such modifications and on such terms as the tribunal thinks appropriate. But that is the point. The reason why I have pointed to the difference in approach between a Part 5 application, in which the starting point is the terms that you've already got, and a Part 4 application, where the starting point is what the operator is seeking, subject to such modifications as the court may impose. Now, while I'm on Ashlock, as a general principle, I would also cite the words of Lord Justice Davis in paragraph 110, page 236 of the bundle. I was not much moved by the appeals of Mr. Seidler to the asserted merits, and then dropping down 5 lines, but the actuality is that both parties are commercial concerns operating for profit. In truth, the underlying competing considerations reflect the fundamental dichotomy between the provision of communication services for the public benefit on the one hand, and the need for acknowledgement of private property owners' rights on the other, and the delicate balance that needs to be struck, I think that should be not stuck, struck and maintained between the two. Now that's an important corrective, because one hears in all these cases, and one can't blame them for it, but the operators always say, well, of course, the public policy behind the Act is to drive forward with new infrastructure so that the public has high-quality communications network. And of course that's right, but it's not the overriding consideration that overrides all interests of the landowner. The point is that one gets to a position where you have to strike a delicate balance between the interests of these competing parties.
He said in that case it was the transitional provisions that had struck the balance, and he said they were crucial to the case. What were the transitional provisions, and do they affect that last submission?
I don't think so, in the sense I had read that as being a more general expression of the delicate balance that needs to be struck, as shown by the Part 5 procedure.
Well,
and then he goes on.
Sorry,
of course. But then he goes on to say the transitional provisions are crucial, and as I read them, they directly confront this perceived dichotomy. They give a degree of primacy, as it were, to subsisting rights. So, but if one asks, well, how is that right? Answer 3412 tells you that it gives a degree of primacy to existing rights. That's where you get it from. And that is really the O'May case that Lord Justice Lewison referred to, in which the equivalent words in section 35 of the 54 Act were subjected to scrutiny, and this principle then emerged.
That probably means we're about to go to O'May. Just before we do, why did the operator here want to rely on paragraph 20? Why did it want to rely? I haven't read the facts sufficiently to know why it wanted to rely on Part 4 rather than Part 5.
On this case, it was limited, as a result of the transitional provisions, to a renewal of its tenancy under the 54 Act. And therefore it had to go to the county court to renew it. And for whatever reason, that was not considered their optimal position. Whereas what they did consider to be better for them was that if they went down paragraph 20 route, they wouldn't be so circumscribed by the 1954 regime. So the point about 3412 comes in that in this case, in that immediately you, the operator, are required to go to the county court to establish your new lease. But that's the last time on which you do it. The next time you want it, you're making an application under Part 5,
Yes.
because that's written into the 54 Act now.
Yes.
So, so what Lord Justice Lewison is referring to here is that the paragraph 20 alternative which was being put forward allows the operator to escape the constraints of things like Section 35 and at the next renewal, paragraph 3412 of the 54 Act and then of the Code, both of which make the terms of the existing tenancy the starting point when in default of agreement the court or a tribunal is required to fix the terms and so on. So it must have been thought that there was an attractive alternative by going to paragraph 20 and bypassing the constraints. I'm just reminding myself of the word used. It's actually restrictions is the word used by the Deputy President, which are approved by Lord Justice Lewison. The operator would also escape the restrictions of Section 35 and paragraph 3412. So that's not what was intended. Sorry, I should have just pointed out paragraph 102. His Lordship said, "I agree." So he's approving what is said by the Deputy President in the court below. So that is a case which shows there is a real difference between a Part 5 and a Part 4 application. And you can't escape the restrictions that are imposed by a provision like 3412. So I now need to go to O'May to show the court what Lord Justice Lewison had in mind by that. O'May is in tab 1. Now, this was a renewal of a business tenancy, a 1954 Act application, where the landlord wanted to change the terms of a service charge provision in the new lease from what it had been in the old lease. And he had perfectly good estate management reasons for doing that, and it was, on the evidence, it was consistent with market practice at the time of the application for a new lease. All of which is taking the position from the landlord's point of view. But, the House of Lords said, that's not appropriate because Section 35 requires you to have regard to the terms of the lease, and that means that that is your starting point, and you need to demonstrate a reason for changing it. And what's more, something that is in the interests of one of the parties only, even if those are well established, is not enough to get over the test of, I think, it's called essential fairness between the parties. So just to show your lordships and your ladyship how that works, we can go to the judgment of Lord Haleshan. And there's a passage sidelined on page 16 of the bundle. Where his lordship deduces three general propositions. It's clear from section 34, which is the rent provision in the 54 Act, that in contrast to the enactments relating to residential property, Parliament did not intend, apart from certain limitations, to protect the tenant from the operation of market forces in the determination of rent. In contrast to the determination of rent, it is the court and not the market forces which, with one vital qualification, has an almost complete discretion as to the terms of the tenancy, which, of course, in turn must exercise a decisive influence on the market rent to be ascertained under section 34. And three, in deciding the terms of the new tenancy, as to which its discretion is otherwise not expressly fettered, the court must start by having regard to the terms of the current tenancy, which ex hypothesi must either have been originally the subject of agreement between the parties or themselves the result of a previous determination by the court in earlier proceedings for renewal. A certain amount of discussion took place in argument as to the meaning of having regard to, despite the fact that the phrase has only just been used by the draftsman of section 34 in an almost mandatory sense. I do not in any way suggest that the court is intended or should in any way attempt to bind the parties to the terms of the current tenancy in any permanent form. But I do believe that the court must begin by considering the terms of the current tenancy, that the burden of persuading the court to impose a change in those terms against the will of either party must rest on the party proposing the change, and that the change proposed must, in the circumstances of the case, be fair and reasonable, and should take into account, amongst other things, the comparatively weak negotiating position of a sitting tenant requiring renewal, particularly in conditions of scarcity, and the general purpose of the Act, which is to protect the business interests of the tenants so far as they are affected by the approaching termination of the current lease, in particular as regards security of tenure. I derive this from the structure, purpose and words of the Act itself. If I required confirmation of it, I'd find it in passages from, and then he cites several cases. And dropping down to the next complete paragraph, a further point which was canvassed in argument, and with which I agree, is that the discretion of the court to accept or reject terms not in the current lease is not limited to the security of tenure of the tenant, even in the extended case referred to by Lord Justice Stanning in Gold. There must, in my view, be a good reason, based in the absence of agreement on essential fairness, for the court to impose a new term not in the current lease by either party on the other against his will. Any other conclusion would, in my view, be inconsistent with the terms of the section. Subject to this, the discretion of the court is of the widest possible kind, having regard to an almost infinitely varying circumstances of individuals, leases, properties, businesses and parties, and so on. Now, that's the salient part of Lord Haleshan's judgment. We could also look at Lord Wilberforce's explanation at page 23 of the bundle, about halfway down the page. The Act, in the portion of it which deals with business tenancies, is in the main a discretionary Act, giving wide powers to the judge to grant and settle the terms on which the business tenant is to have a new lease. This applies particularly to sections 33 and 34, which relate to the duration and rent. The crucial section for present purposes is 35, which relates to the terms of the tenancy other than terms as to duration and rent. This section contains a mandatory guideline or direction to have regard to the terms of the current tenancy and to all relevant circumstances. The words "have regard to" are elastic. They compel something between an obligation to reproduce existing terms and an unfettered right to substitute others. They impose an onus upon a party seeking to introduce new or substituted or modified terms to justify the change, with reasons appearing sufficient to the court. See Gold, quote, on strong and cogent evidence, per Lord Justice Denning. If such reasons are shown, then the court, applying all relevant circumstances, may consider giving effect to them. There's certainly no intention shown to freeze, or in the metaphor used by the judge, to learned counsel, to petrify the terms of the lease. In some cases, especially where the lease is an old one, Many of its terms may be out of date or unsuitable in relation to the new term to be granted. If so, or for any other good reason shown, the court has power to order a modification by changing an existing term or introducing a new one, e.g. a break clause. Before doing so, it will consider any objections by the tenant, and where there is an insoluble conflict, will decide according to fairness and justice. And then over the page, the sideline passage on page 24, the landlord's case for a shift of the burden, as I've indicated, rests on two broad foundations. The first is that such a shift is for quite genuine and respectable reasons in the interest of the landlord. I accept this. I think it is shown by the evidence that in the present and foreseeable state of the property market, a freehold interest in commercial property, at least in London, commands a higher price if let on clear leases, i.e. leases in which the tenants bear all the costs and risks of repairing, maintaining and running the building, of which their demised premises form part, so that the rent payable reaches the landlord clear of all expenses and overheads. Thus, the landlord demonstrates a genuine interest in departing from the existing terms of the lease. Secondly, the landlord asserts that new leases of property, such as that with which we are concerned, are now granted and accepted by tenants as clear leases. This too is supported by the evidence. But in my opinion, though a relevant circumstance, it is not decisive. There is no obligation under Section 35 to make the new terms conform with market practice, if to do so would be unfair to the tenant. And there's no inherent necessity why the terms on which the existing leases are to be renewed should be dictated by those of fresh bargains which tenants may feel themselves obliged to accept. The court has to compare the advantage desired by the landlord with the detriment to be suffered by the tenants, and consider whether any monetary compensation offered against that detriment ought fairly to be imposed upon the tenants in exchange for acceptance of the detriment. That money is not necessarily fair compensation for a change in existing rights, is obvious in itself, and is well recognised by the law in relation, for example, to compulsory acquisition and to the granting of damages instead of an injunction. And then over the page, Lord Keith, Lord Scarman and Lord Brandon agree with both Lord Haleshan and Lord Wilberforce. So this is, if I may say so, this is well established and well understood in 1954 Act cases. If there's a dispute about a term, then you look first of all at the existing terms of the existing lease. And if some change is required, it's for the party proposing the change to establish it. And that is not a question to be considered purely from the point of view of the person proposing the change. Even if it's entirely beneficial to him and entirely consonant with market forces as they exist at the time of the application. There is a question of essential fairness as to whether or not such a term should be imposed upon a reluctant, in this case, tenant.
In that case, the landlord's advantage was at the expense of the tenant, because it was better terms for the landlord meant worse terms for the tenant, expressly. Yes, I'm not sure it goes that. That might be a possibility. That was the context in which they were saying all those matters.
I think that's probably right. I'm not sure that it was exactly equivalent, as it were, but there was certainly some disadvantage for the tenant because he was being required to take on risk that at the moment he didn't have.
Yeah, he didn't have the obligations. Yeah.
So what the evidence was about the extent of that risk, I don't think it's dealt with.
In terms of the economic implications, it may be more complicated in the sense that if you get less onerous terms, you pay a higher rent.
Yes, exactly. So there may be counterbalancing issues to be determined. Indeed. So overall, in the end, it's a different package. So what is the court's approach to the request for a different package? Answer: if the tenant doesn't want it, even if it's a really good idea for the landlord, the tenant isn't obliged to accept it. Now, that is what the Lord Justice Lewison was referring to in Ashlock, saying that is a restriction on your request for terms to be included in your new in this case, code agreement. And that's the point of a provision like paragraph 34.12, that it restricts what's available to you. And what I'd like to do, whilst on the 54 Act, is just to take your lordships and your ladyship to a couple of other cases, both of which are under the 54 Act, which show the way in which the court does not allow an agreement to become petrified, to use the phrase that counsel had used, or frozen, as Lord Wilberforce put it, but it allows a new lease to respond to changes in the law that may have taken place since the original lease was granted. And that is relevant to consider because, of course, since this lease was granted back in 1999, we've had a whole new code created under the Digital Economy Act. This is the code we are now dealing with, which has substantially changed a large part of the landscape of relations between parties like these two, that's operators and site providers.
And in particular, paragraph 17 and the no network assumption.
Exactly. Now, just on those two cases, the first is at tab 2 is Cairn Place. The Cairn Place was a case in which there had been a covenant for the tenant to pay the landlord's costs of settling the lease, which was a custom at the time the lease was granted. And so, not surprisingly, the landlord wanted a similar position put into the new lease. But what had happened was that in the meantime, an act called the Cost of Leases Act 1958 had been passed, which provided that covenants or obligations to pay the whole or part of any other party's solicitor's costs of the lease were not to exist, were abolished. And one can see that at page 33. About halfway down the page, there is the heading, the cost of the leases, and one sees just after letter F, Section 1 of the Cost of Leases Act provides, notwithstanding any custom to the contrary, a party to a lease shall, unless the parties thereto agree otherwise in writing, be under no obligation to pay the whole or any part or of any other party's solicitor's costs of the lease, and so on. And dropping down the page, this is, I think this is Lord Justice Cumming Bruce. Yes, Lord Justice Cumming Bruce says at the bottom of the page, 2 lines up, with respect to the judge, we do not accept her decision on this issue. In 1954, that's the date of the lease, there was a custom that the tenant should pay the landlord's costs of preparing a lease, which was a practice generally followed by conveyancing solicitors in the absence of express agreement. So when in 1972 the lease between the landlords and Tartan Textiles included 431, the clause was consistent with the general practice. And before the Cost of Leases Act came into operation, there's no doubt the court had the power to embody it as another term in the new lease. But in 1958, Parliament relieved the tenant of the usual obligation. Thereafter, it was only if there was an express agreement in writing whereby the tenant agreed to pay the landlord's costs of preparation of the lease that the tenant was under an obligation. Where Parliament has enacted a later act designed to relieve tenants of a specific obligation, it's not, in our view, a correct exercise of judicial discretion to use the wide power conferred upon the court by the general words of Section 35 to deprive the tenant of the protection conferred upon him by a later act dealing specifically with this very obligation. Perfectly correct to say that Section 35 deals with the powers of the court and not with the agreement of a term by the parties, but it doesn't follow that the court, when exercising discretion, can fairly and reasonably deprive the tenant of a protection that Parliament conferred upon him. So Section 35 makes renewal applications responsive to changes in the law. It doesn't operate to petrify or freeze those terms.
How does that work in that particular case? Because the 72 renewal was after the 58 Act anyway.
Yes, you'll have to give me a moment on that one, my lord.
I accept the general principle, and it may not matter to it, but it's slightly odd.
I think there's something about bringing the 58 Act into force, but
Isn't it in that paragraph just between A and B? Before the Cost of Leases Act 1958 came into operation, there's no doubt the court had the power to embody it as another term in the new lease. So is it that the provision hadn't, the 58 provision hadn't come into effect?
Yes, I don't have the date of the 58 Act coming into operation, but that may be
Very odd to bring an act into operation sort of some 20 years after it's passed.
fine.
Perhaps they missed a trick in 72 is all.
Well, that was what was going through my mind. It's just maybe it had crept in because nobody thought about it, and they agreed to pay it.
So here, if anybody was relying on Section 35, it was the landlord to say you had to have regard to the terms of the old lease.
Yes.
That's rather different from O'May, where O'May was worried about the interests of the tenant. Can a landlord rely on Section 35 to say we better keep it as it is, even though it's in the tenant's interests?
Yes, there's no reason in principle why a landlord could not take it. It's the same principle that applies to both parties.
Yeah.
So that's the point about it being a starting point for the consideration of what should be the new terms. That is going to be something that affects both parties. And why I've expressed the principle as being it's for the party wanting the change to justify the change. And that could be either party.
Yeah.
So in the same vein of responding to changes in the law, I'll take this quite quickly if I may, the next case behind tab 3 is the Wallace Fashion and CGU Life case. And the relevant change to the law there was that the Landlord and Tenant Covenants Act 1995 had completely transformed the landscape of what a landlord's rights were after an assignment of the tenancy. And the issue, therefore, arose as to whether or not, in the view of the circumstances of that change in the law and the provision that law introduced for the authorised guarantee agreement to be a requirement that a landlord can ask for, whether that should be put into the new lease as a requirement because of the change of the law. And the narrow issue, it wasn't so much that there shouldn't be there should or should not be the requirement. The narrow issue one can see on page 39 of the bundle. Paragraph 9. So far as paragraph 17C is concerned, Wallace proposes it should be in these terms. For the purposes of section 19(1)A of the 1927 Act, it's further agreed that any consent of the landlord to an assignment of the whole of the demised premises may be subject to condition that, and then in bold, where reasonable, the tenant shall prior to the proposed assignment being completed, execute and deliver to the landlord a deed which shall be prepared by the landlord's solicitors containing covenants on the part of the tenant in the form of those contained in the 7th schedule, defined as the present tenant. So the point was, on an assignment, the landlord would have said, before the 95 Act, on an assignment, I would still have your covenant to tide me over for the rest of the lease. But the 1995 Act says I can't have that anymore because you're no longer the person in possession of the residue of the term. But the 1995 Act does allow me to contend for an authorised guarantee agreement, as it were, to fill in the hole that the Covenants Act has taken away from me. And so I want that put back in instead. And the tenant's position was, well, I don't mind that happening, but only where it's reasonable to ask for it. And that is consistent with the overriding requirement that a covenant against assignment was subject to the requirement of reasonableness, consent not to be unreasonably withheld. And so you can have your AGA if it's reasonable to ask for it in the circumstances. So the issue was about the reasonableness of it. And this is Mr. Justice Neuberger considering that issue, and he goes through page 40 of the bundle. He goes through the general approach under the 1995 Act, and then at the bottom of the page he starts some fairly extensive citation from O'May, and then he describes the contentions on both sides. And then at paragraph 21, under the heading discussion, His Lordship says, I've reached the conclusion that Wallace's formulation is to be preferred. So in other words, there should be a requirement of reasonableness. The 95 Act has changed the law substantially. In particular, it prevents a landlord from enjoying the sort of rights which he had under the old law once the tenant assigns the lease. In these circumstances, I do not think the terms of Section 35, as interpreted in O'May, entitle the landlord to say that on a renewal, he should be given as generous terms as the 1995 Act provides. The 1995 Act presents a sea change in the law relating to a tenant's liability after he assigns the lease. And it also alters the law relating to the landlord's power to impose terms on assigning the lease. It doesn't merely represent a sea change in what had been common practice, but in what a landlord can lawfully require, both in terms of what is to be included in the lease initially and what he can demand on an assignment. And then he refers to Cairn Place, and then over the page at 24, I accept that the point in issue in those two cases and the point in the present case are not entirely equivalent. And dropping down, apart from representing a sea change of the law, the 1995 Act could be said to have an equivalently similar effect unless the court otherwise orders the effect of including a covenant, which both parties agree and rightly agree should be included, requiring landlord's consent to an assignment, does not entitle the landlord to require an AGA as of right. He will only be entitled to do so if it is reasonable, unless the court imposes a provision entitling him to do it as of right. And then over the page 29, he comes down in favour of Wallace's formulation, which is that there is a reasonableness requirement, and he says that because it involves striking a fair balance between the interests of the landlord and the tenant. So the 54 Act procedure allows for changes to be accommodated, changes in the law to be accommodated when one comes to consider new terms. Now, the particular change that has taken place in this context is paragraph 17, and that I must therefore go back to the code now and show how this fits in. And the code is behind tab 13 of the authorities bundle. If I could invite you to turn up paragraph 17. The first point, this is under the general heading, power for operator to upgrade or share apparatus. One, an operator, the main operator, who has entered into an agreement under Part 2 of the Code, may, if the conditions in paragraphs 2 and 3 are met, upgrade the apparatus or share the use of the apparatus with another operator. Now, first point is, again, it applies to agreements under Part 2 of the Code, but that will encompass voluntary agreements or imposed agreements or indeed renewed agreements. So any kind of agreement which has become a Part 2 agreement, either because it was originally there or because one of these provisions has made it a Part 2 agreement. And then it imposes these two conditions under 2 and 3, subject to which, though, the operator is entitled to upgrade and share. And the first condition, 2, is that any changes as a result of the upgrading or sharing to the electronic communications apparatus to which the agreement relates have no adverse impact or no more than a minimal adverse impact on its appearance. And the second is that the upgrading or sharing imposes no additional burden on the other party to the agreement, which is then glossed in subparagraph 4 in this way: for the purposes of subparagraph 3, an additional burden includes anything that has an additional adverse effect on the other party's enjoyment of the land or causes additional loss, damage or expense to that party. So those are the conditions that have to be satisfied to enjoy the upgrading and sharing rights that paragraph 17 allows. And then subparagraph 5 is important in that any agreement under Part 2 of this code is void to the extent that it prevents or limits the upgrading or sharing in a case where the conditions in paragraphs 2 and 3 are met of the apparatus to which the agreement relates, or it makes upgrading or sharing of such apparatus subject to conditions to be met by the operator, including a condition requiring the payment of money. So, the logic of that, one possible consequence, which the cases acknowledge, is that paragraph 17 creates a sort of minimum right or a floor, double OR that is, for the enjoyment of upgrading and sharing rights in code agreements. It doesn't say you can't agree something more generous, that is to the operator, but it does severely limit the ability of a site provider to provide conditions on the exercise of upgrading and sharing rights. Indeed, they are void to the extent that they are they prevent upgrading and sharing rights from being exercised where subparagraphs 2 and 3 are fulfilled, and they are void to the extent that they make the exercise of the rights subject to conditions, including payment conditions. Now, clearly, therefore, that needs to be taken into account when one's considering the terms of a new agreement under Part 5. Because the new agreement that the court grants will be an agreement under Part 2, or treated as an agreement under Part 2, and therefore paragraph 17 rights will be granted to the operator. And to that extent, therefore, one must read paragraph 34(12) accordingly, rather in the way that a similar kind of position was examined in the Cairn Place case and the Wallace Fashion case. There's been a change in the law that has transformed one aspect of the terms. You can't immediately replicate the existing term, or if you do, it'll be rendered void or restricted by the addition of paragraph 17 rights. So you're trying to settle what is the form of upgrading and sharing in the light of the change in the law. Now, that's the way it works under 3412, but there's a separate point here as well, which is that paragraph 17 is not just a minimum right or a floor. It also sets a benchmark or a standard for upgrading and sharing rights, which involve the satisfaction of two conditions, both of which have been introduced for the protection of landowners. And when I say that, I'm not suggesting that the court or tribunal could not order wider rights in an appropriate case. But I do submit that the starting point is the rights granted by paragraph 17 for upgrading and sharing, and that it is for a party who wants wider rights to justify why they should be granted. Now, this point has arisen in the context of paragraph 20 applications, although I'm not aware that it's been considered specifically in the context of part 5 applications. But on the part 20 front, the first case is a case of persuasive authority only, which is the Lands Tribunal of Scotland in Fotheringham, which is tab 5, Cornerstone and Fotheringham. This is the first one of the three that I'm going to take the court to. It relates to an order made on the 24th of July 2020 in an application from Code Rights under paragraph 20. So it's as it were, an originating agreement. And the matters remaining to be resolved are set out at paragraph 9 on page 78 of the bundle. And little Roman 2 is the extent of the applicant's sharing rights. And then dropping down the page, one sees the heading, the extent of the applicant's sharing rights. And this is what the Scottish Tribunal says. The dispute between the parties here is as to whether the sharing rights under the agreement should be confined to those envisaged in paragraph 17 or should be unrestricted. They then set out the terms of paragraph 17 and at 13 comment on what's in issue. Just dropping down to the 5th line. What is clear, however, is that the respondent wishes to add the words pursuant to the code immediately after the word share. The applicants take that, rightly we think, since this is the paragraph which deals with sharing, to be a reference to paragraph 17 of the code. The effect of the revisal would be that sharing rights would be subject to the two conditions in subparagraphs 2 and 3 of paragraph 17. And then the first question which the tribunal considers is whether it's competent for the tribunal to award rights beyond the terms of para 17. And dropping down the page to para 16, the conclusion is that they can. The tribunal can impose sharing rights wider than those provided for by paragraph 17. And that's, however, by concession, rather than because they'd reached a concluded view on the point. But then they go on in 17. The applicant's submissions deal at length with the importance of telecommunications equipment sharing. It's a statutory imperative in terms of the Electronic Communications Code regulations. Regulation 3.4 of which says a code operator, where practicable, shall share the use of electronic communications apparatus. It's also a commercial imperative for the various code operators, as the affidavit of Mr. Harris, the applicant's head of special products, dated the 16th of June, explains. It allows them to save on costs, which in turn is in the public interest. It improves network coverage of the less populous part of the country by allowing operators to make economies. It's desirable in planning terms, avoiding unnecessary proliferation of sites and masts, as is reflected for Scotland in the Scottish planning policy. And of course, it's a sine qua non for the providers of passive infrastructure, whose whole raison d'etre is the provision of sites and masts on which active as opposed to passive telecommunications equipment can be installed. Just pausing there, my friend's client is, of course, one of those infrastructure providers, in the jargon, a WIP, WIP, wholesale infrastructure provider. The point is that, so that's the general policy behind it, but the tribunal continues at paragraph 18. All of that is known to and understood by the tribunal. It was also known to and understood by Parliament when it enacted paragraph 17. So we were considerably surprised to find it said at paragraph 64 of the applicant's substantive submissions that the restriction of sharing rights to the extent provided for by paragraph 17 of the Code would have devastating consequences for operators under the Code, infrastructure providers in particular, and thus for the public interest too. And then dropping down to 20, assuming as we do for the purpose of the argument that the applicants are correct in saying that it is competent for this tribunal to grant rights which go beyond para 17. Whether to grant such rights is a matter for our discretion. It would require pretty compelling evidence to justify the imposition on the respondent of rights which could result in a more than minimal adverse impact on the appearance of the mast, or more importantly, an additional burden which has an adverse effect on his enjoyment of the land or causes him additional and unquantified loss, damage and expense. Paragraph 17 is the only point at which the Code addresses sharing rights. There's no separate provision for infrastructure providers. In enacting it, Parliament was striking a balance between the interests of the operators and the public on one hand, and site providers on the other. The tribunal would therefore need to be persuaded there was some justification for removing the level of protection for site providers which Parliament has provided. The onus of persuading us should, in our view, be on the applicants. But in certain points in their submissions, the applicants appear to invert that onus. And then there's an example of that. And then over the page, in this, set 23, in this regard, we cannot help thinking that any prospect of difficulty in the way of paragraph 17 being used by the respondents to impede sharing or somehow thwart what the applicants wish to achieve in the way of sharing is more imagined than real. We say that because we imagine that the new mast, once fitted with its active equipment, will look much like the old and will have no greater adverse effect on the respondent's enjoyment of his land. There ought not, therefore, to be any reason to apprehend that restricting sharing rights to those envisaged in paragraph 17 is going to tie the applicant's hands in some way. And then they make a slight alteration, 25. The alteration we've made to the draft agreement in this respect is to cause clause 812 to read, the operator may, without the grantor's consent, share the rights with third parties, which expression shall, for the avoidance of doubt in this context, include the operator's shareholders, to the extent permitted by paragraph 17 of the Code. And so that brings in the conditions of subparagraph 2 and 3. Now that's similar to what we are contending for on this application, this kind of reasoning. But if I could just pick up the reasoning in Fotheringham, the conditions in paragraph 17 are no adverse impact or no more than minimal adverse impact on appearance, and secondly, no additional burden, which is glossed as no additional adverse effect on the enjoyment of the land or additional loss, damage or expense. Now, it follows from that a claim to a wider right is a claim to be able to upgrade or share the apparatus with the effect of more than a minimal adverse impact on appearance, and or putting an additional burden on the landowner in his enjoyment of the land, or involving him in further loss, damage, or expense. So it's possible, and I don't exclude the possibility, but it's possible to show that such a clause is appropriate in certain circumstances, but it would require some pretty striking circumstances or pretty compelling evidence, I think as the Land Tribunal of Scotland puts it, to get that to stick in an application of this kind. Looking broadly at the essential fairness issue, the Parliament has worked out a fair balance. So there must be some reason to upset the balance that Parliament has set and to award a wider right, in particular circumstances, to an operator, or in this case to a whip. Sorry, just to be clear, a whip, like my friend's client, is an operator for the purposes of the definition in the Act. So you can't make a distinction on that ground, but the evidence that he wants to rely upon is that because he's an infrastructure provider, he has to be able to share with other, as it were, true operators, network operators.
I just talk around that for a moment. So suppose an operator knows now that he wants this particular mast. So he can apply for that. And he's given it. Now it turns out he wants a mast that's a bit taller and therefore, we'll assume, has a more than minimal impact on appearance. If he'd known from the start that he wanted that, he potentially could have applied for it and have got it, and you would have got no more compensation.
He could have done, but there would have been on a Part 5 application, we're already dealing with...
Can I just focus on Part 20,
yes, okay.
paragraph 20,
paragraph 20
Part 4 for a moment, to make it easy.
Okay.
So suppose, first of all, he knows he wants a short mast. He asks for that, he gets it, you get some compensation. Now instead he knows he wants a tall mast, and he asks for that, he gets that, you get the same compensation. Because you're not allowed to take into account anything very much, so it's the same compensation.
Broadly speaking, yes.
Now at stage 1, he knows that he wants the short mast now, but may want the tall mast in the future. Has no financial implication for you which one you have, which one he gets. Why shouldn't a tribunal say, well, you can have either?
Well, if the tribunal has some evidence before it as to what are the implications, what precisely in prospect, and what are the implications, then the court or tribunal is in a position to make an assessment of that, and in particular, to see whether or not there is any more than minimal adverse impact on appearance. So it's not just impact, it's adverse impact. So does it infringe that test? So if the court has an idea about what's coming and it's explained as to what it's going to look like, and you can perhaps produce a mock-up, the court can say, I see, then I am or I am not going to allow you to build something that large.
All right, so I follow that. In deciding whether or not to allow the operator potentially to build Mark II, which has a more than minimally adverse effect, why should the tribunal ask itself whether there is whether there are pretty striking circumstances or pretty compelling evidence? Why shouldn't it ask itself whether, supposing that the taller mast were now being applied for, it would be appropriate to allow the taller mast?
Well, if the evidence is that there will be no adverse impact,
But we're assuming that Mark II mast would have an adverse impact. But we're assuming that the tribunal, looking from the start at an application for the Mark II mast, would have said, okay, why should the fact that the operator is asking now for Type 1 mast, but envisages it will want Mark II mast in the future, mean that the operator has to produce pretty striking circumstances or pretty compelling evidence, when, had it been Mark II mast in issue from the start, that wouldn't have been necessary?
Yes, and I see the point and the force of the point. And the reason I don't have an immediate answer to it is that is not the case that's put forward. But the reasons I give, if the court has some concrete evidence as to what a new mast is going to look like, its dimensions, and therefore what its appearance and the impact on the appearance of the property is going to be, it can make a sensible decision without further, as it were, further compelling evidence. But what is being contended for here is that there is an unconstrained, unrestricted right to upgrade and or share, even if the consequences could be highly damaging to the appearance of the property, or could bring about some particular prejudice as yet unforeseen to the landowner in its enjoyment of its land, or cause it loss in some other way. So we're embarking on a rather speculative process as to what is coming, and it's actually the risk involved and the speculation that's involved. This is the real reason why paragraph 17 in our submission cannot be avoided. It is the very protection which Parliament has given to the landowner.
May I ask one question on that? Because the tribunal appeared to have been influenced by the fact that this was in the South Downs National Park and there were therefore planning restrictions, which meant that theoretically one can understand the force of all that you say, but in this situation it wouldn't be, because they wouldn't get planning permission for anything that was intrusive.
Well, I'm not sure there's any evidence that underpins. I mean, that's all. It's all very interesting possibility. But if I could put it this way, if a landowner had the option of relying exclusively on the planning authority doing the right thing, as the landowner would see it, is that all that he would want, or would he prefer also to have a private right to control unwanted matters, particularly when he lives and works in an area of outstanding beauty such as the South Downs National Park? So yes, there are levels of protection, and planning is one of them. But the issue here is, in such a sensitive area, should a private right be overridden merely because the operator says, I need to have as much flexibility as possible in what I can offer to network operators? Yes, my junior is reminding me that on your Lordship's example, it might also be worthwhile bearing in mind that under the paragraph 23.5, we are not, which is the least possible loss and damage. We're not just talking about the landowner. We're talking in that context also about people using the land. and visitors and so on. So this is quite a wide-ranging thing. You'll need to be able to establish as an operator that none of those persons are going to be adversely affected.
But that isn't a paragraph 17 point.
That's not a paragraph 17. It's a further point, though, that when one considers...
I mean, that might be a reason for the tribunal saying, well, you can't have your Mark II mast. But it wouldn't be based on paragraph 17, it would be based on paragraph 235.
Yes. Yes. But, well, yeah. I mean, because at the end of both of these considerations, there is a discretion to be exercised. It may be that they play alongside one another, let's put it that way. Now, that's the Scottish authority. The English authorities are University of Arts, which is the one behind tab 7, Cornerstone and University of Arts London, which is, as one sees on page 134 of the bundle, paragraph 1 of the judgment. This is an application under paragraph 20, again. And the relevant part for my purposes, begins at 178 on page 167. Just turning back a page, this is under the general heading, the right to upgrade and the right to share. So 178, the right of a code operator to upgrade its equipment is immensely important in view of the constantly advancing nature of technology, and we need not overload this judgment by explaining that. Similarly, the practice of sharing infrastructure is prevalent in the telecommunications industry and achieves a number of economies. Some code operators, the present claimant among them, are providers of infrastructure for the use of operators that provide electronic communications networks, and therefore, without the ability to share their equipment, they are out of business. For those reasons, which we could elaborate over many pages, but we take them as well established, the Law Commission recommended that code operators must have the right to upgrade and share their equipment without being charged extra for doing so, as was prevalent under the old code, subject to safeguards for site providers. That recommendation was accepted and expressed in paragraph 17 set out above. Paragraph 17(2) and 3 enable site providers only to require the safeguards there set out as to the appearance of the apparatus and protection from initial burdens. And then they make the point over the page, it's open to the parties to agree or the tribunal to order that the agreement should include the right to share the site and or upgrade the equipment without those safeguards. Possibly with extra consideration being payable. And then the issue in this case, 181, the claimant's draft provisions for upgrading and sharing do not include those safeguards. And then over the page, 187, turning then to the terms of the agreement, we begin by considering the starting point. Is it for the claimant to justify rights broader than the minimum offered in paragraph 17, or for the respondent to justify insistence on those safeguards? We take the view that the starting point is paragraph 17, which was drafted to express policy framed in full knowledge of the importance of sharing and upgrading. If the claimant wants more than the minimum, it should justify that. If, however, the claimant can show that in this particular case, there is little or no reason why the safeguards of paragraphs 17, 2 and 3 should be included, then that may be a reason to exclude them. Starting in with the claimant's reasoning, we're unpersuaded by the argument that the importance of sharing and upgrading mean in themselves that unlimited rights should normally be granted. The Lands Tribunal for Scotland was faced with that in Fotheringham, and then they quote from paragraph 18, which I think I've taken your ladyship to. 190, the Lands Tribunal for Scotland in that case included the paragraph 17 safeguards in the provisions for sharing and upgraded. However, the decision whether to include those safeguards will depend on the facts of an individual case. And then they go on in relation to the facts of that case, which in 190, the respondent has raised no concern at all about the appearance of the building. It's in effect going to be demolished before very long, and so on. So I mean, there are cases where appearance is just completely irrelevant, and no prejudice might be shown by any particular activity, and those would be reasons for ordering something wider than paragraph 17. But that's not this case, because the appearance is extremely important, and both in the case of upgrading and sharing, what's not presented to either us or to the court is any evidence about what the future entails. So nobody knows what's coming, including my friend's client. In the end, they just want flexibility for their business purposes, and because technology is difficult to predict, but without reference to any consequences that might have for the landowner. The last case on this round is London and Quadrant, which is behind tab 6.
In that case, they also left in the 17.3 restriction, didn't they?
Yes, they did, yeah. And the London and Quadrant is another paragraph 20 application, and I could perhaps take the head note at H7 on page 102 of the bundle. H7 is paragraph 3 of the head note. In respect of upgrading and sharing, the first condition in paragraph 17.2, which is the minimal adverse impact, did not relate to whether there would be an adverse impact on the appearance of the host building, but to whether there would be an adverse impact on the appearance of the apparatus itself. The lack of any de minimis exception in the second condition meant that the prohibition, no additional burden, was to be read strictly to extend to any additional adverse impact on the site provider's enjoyment of its land, or any additional loss, damage or expense. Paragraph 17 represented the irreducible minimum in terms of upgrading and sharing rights, to which an operator was entitled under a code agreement. A court or tribunal may impose terms as stringent as those in paragraph 17, but not terms which are more stringent. The minimal upgrading rights conferred by paragraph 17 were insufficient for a code agreement for a term of 10 years, bearing in mind the uncertainty of future developments in technology. It would not be appropriate to impose terms which may significantly impede upgrading in future, and to do so would diminish the public benefit which is the object of the code agreement. The appropriate terms were those which permitted upgrading without limit, but which restricted the number of persons with whom the use of the infrastructure may be shared in order to cause the least possible loss and damage. On the facts, the appropriate number of additional persons was 2. There we have a case in which evidence was adduced and accepted that something slightly wider was allowed, but so far as principle is concerned, could I go to page 115? Paragraph 76. Despite the rebalancing of the Law Commission's recommendations in the Code as enacted, we consider that the Law Commission report does provide valuable guidance on the policy underlying paragraph 17 of the Code, which has plainly been modelled on paragraph 345, the reference to clearly identifiable cases where upgrading and sharing have no physical implications at all is an apt description of the scope of paragraph 17. So it begs the question of what upgrading means. For these reasons, we accept Mr. Radley-Garden's submissions that paragraph 17 represents the irreducible minimum in terms of upgrading and sharing, which an operator is entitled to under a code agreement. An operator may request a specific code agreement right to upgrade, and if it's granted in unrestricted terms, paragraph 17 will not limit its exercise. It's undesirable for the extent of upgrading or sharing to be left unclear, and it's open to an operator to ask the court for unqualified rights, or for a site provider to seek to impose conditions as stringent, but not more stringent than those in paragraph 17. And then you have to have regard to 23.2 to 8. There was no dispute for us that the tribunal has jurisdiction. In the University of Arts, the tribunal proceeded without questioning its jurisdiction to modify the effect of paragraph 17, and for the reasons we've already given, we have no doubt it was right to do so. The onus is on the party wishing to depart from paragraph 17 to justify its request, as the tribunal said, and then they quote from paragraph 188, which I've taken the court to. So, as a matter of principle, this was a case in which, again, the starting point is paragraph 17. On the evidence, something wider was permitted, but then that's an evidential question.
But you don't find here anything about pretty striking circumstances or pretty compelling evidence.
No, you don't.
It's just on the evidence.
You don't. And I don't want to hang my hat on that either. I mean,
Yep.
it's pretty. It's a very subjective way of putting it anyway. I mean, you might think that some evidence is compelling. In fact, in the end, it's just evidence that justifies doing something different.
Yep.
What makes it compelling is the fact that your base point is something that's been set by Parliament with knowledge of how these things were supposed to operate and the importance of the rights that were being included in the code in this respect. So Parliament set this benchmark. And it's against that context that one would need, shall we say, striking. I mean, I don't need to use further adjectives, but compelling evidence. I think it's rather like the gloss on the rectification claims, where it said that you need pretty compelling evidence to get away.
And that's to overcome the inherent improbability.
Exactly. Now, substitute for to overcome the inherent improbability the fact that Parliament has defined a particular type of upgrading and sharing with protection for the landowner as it were the basic position. And you need to justify some departure from that. Just because London and Quadrant referred to the Law Commission report, it might be helpful to look at those extracts, which are behind tab 14 in the authorities bundle. And page 313, at the bottom of that page, paragraph 329, is a heading, the upgrading and sharing of electronic communications. I needn't read all that now, but the discussion and recommendation, I do invite your lordships and your ladyship to read that section.
Sorry, which page was that again?
That was starting at page 313 of the bundle, and it's paragraph 329 of the report. And we've sidelined some interesting observations that are made. And then we need to jump forward to paragraph 339 under the heading Discussion and Recommendations, that is on this topic, upgrading and sharing. What's very clear to us is that quite apart from the commercial realities of the deals already agreed in the marketplace, the impossibility of disturbing these In the majority of cases, both the sharing and the upgrading of electronic communications apparatus have serious technical implications. This means, with an exception that we discussed below, they cannot be permitted as a matter of course by way of an ancillary right for code operators. The upgrading of equipment, usually the substitution of equipment, sometimes the addition of more, generally involves physical change. Changing an antenna may or may not have implications for the structural integrity of the mast. Upgrading may mean a change to a base station or a power supply. The possibilities are so complex that no general provision can make an automatic right to upgrade either feasible or safe. The same goes in general for sharing. Many masts, for example, are not built to be shared and cannot simply have additional antennae added on or different antennae substituted. Furthermore, sharing may have implications not merely for the site provider but also for other code operators using the mast. So in general, it's not possible for code operators to have an automatic right to share or to upgrade equipment. Such rights must be negotiated for or granted by the tribunal. And they point out the range of technical implications and so on, such that automatic rights cannot be given, and it's for the parties to negotiate for them or for the tribunal to confer them. Now, just pausing there, in this case, we're no further forward about the range of technical implications because there's no evidence given as to what technical implications there might be. It's just stated that technology is moving all the time, and therefore we need to remain flexible to accommodate changes. Well, that doesn't give anybody any ability or any comfort that giving the wide rights that are sought would be fair, a matter of essential fairness between the operator and the site provider. And so, just going down the pages, I'm still on page 316, paragraph 343, set against those technical considerations, there's a concern that the lack of automatic rights may generate problems, and then that is discussed. And 348, they talk about the position where sharing or upgrading takes place within the confines of a duct or even a cabinet without physical or visual impact on the site provider. So there shouldn't be a problem there. And in the end, after further discussion, at 3.51, we recommend the revised code should provide that in relation to an agreement or lease commencing after the implementation of the revised code, a code operator shall be permitted to upgrade, and so on, as we see was eventually enacted with paragraph 17. So this balance was struck with knowledge of the importance to code operators, but with protection for landowners, so that they would not be subject to unwanted visual impairment and unwanted prejudice of a financial kind or to the enjoyment of the land. So putting all that together, we say the terms of paragraph 17 are really the starting point. And if there is nothing cogent adduced by way of evidence to supplant the Para 17 terms, then that will also be the end point as well as the start point of the discussion. My lords and my lady, the second area I wanted to go on was the Upper Tribunal's decision and why it went wrong. And conscious of the time, yes. I need to press on. So what I will do, if I may, is just to point the court to those parts of it that we say shows that the tribunal was considering the wrong thing, that is the wrong procedure. And that's page 87 of the core bundle, tab 6, 87, under the heading Discussion and Conclusion about the Disputed Terms. Picking the judgment up at 48, both parties accept the fact that a claimant wants a right does not mean it automatically has to have it, nor is it the case that a respondent can insist on whatever terms it wants. Both parties argue that the tribunal has a judicial discretion as to the terms of the agreement and must engage in a balancing exercise between the needs of the parties. 49 is our understanding of the code is that the tribunal may, not must, so there is a discretion, confer a code right on the claimant, provided that the conditions set out in paragraph 21 are met. The relevant conditions are 21, 2 and 3. Now those two are the threshold conditions on a paragraph 20 application, and nothing to the point as regards part 5. Nevertheless, that is what the tribunal then goes on to consider. There's then the fact that in paragraph 50, 23.5, paragraph 23.5 is considered, which is correct so far as it goes, but that's not the only consideration. And what's wrong about the way in which the tribunal dealt with it is that if one drops down 5 lines from the top of paragraph 50, they say the tribunal may, by the agreement which it imposes, give effect to the code right sought by the operator with such modifications as it thinks appropriate, paragraph 23.1, and on such terms as it thinks appropriate, paragraph 23.2. Now again, paragraph 23.1 is not the process. Paragraph 23.1 applies to paragraph 20 only. So you don't look at what the operator seeks and then see whether it needs to be subject to modifications. You look at the existing agreement and then consider the matter from there. And then at 51, the tribunal turns to the conditions in 21. So they are considering those 2 threshold conditions. And further down the page, at 55, they say the claimant's evidence of the public benefit of what it seeks is unchallenged. Well, that's because that wasn't in issue. Public benefit was not in issue on this application at all.
Would that be right? Why isn't that material in terms of paragraph 34 renewal? I mean, after all, the parties thought that this was a paragraph 33, paragraph 34 application. Presumably, they therefore adduced evidence that they thought was relevant to that application.
The public benefit was a given, in the sense of the policy behind the Act and the existence of this mast on this particular site. That had already been dealt with.
Yes.
That wasn't the point. The point that should have been being addressed here was whether or not the paragraph 17 terms should have been extended in the particular circumstance of this case.
Yeah.
And the threshold conditions are apt to mislead, if anything. If you dwell upon those as being satisfied and then consider what modifications you need to make to what is sought by the operator, you've already gone down the wrong track. You've thought of this as a public benefit issue, when that's just not what we're dealing with. And so 56, they say the conditions in paragraph 21 are met, and the tribunal may therefore impose these rights. And then should it modify them, that's back to 23.1, which is irrelevant to the purpose. Yes, but the way in which it talks about modifying is in relation to that. So then they go on in the light of the need to cause the least possible loss and damage, which is 23.5, which is a relevant consideration, but not the only one. So that's what they say about upgrading, and they say that effectively there shouldn't be any constraint. Then they turn to the right to share, which is at paragraph 58. And here, what the tribunal says is that 59, as with upgrading, paragraph 17 operates as a flaw. These are minimum rights. The Law Commission's intention that if the claimant was to have any more extensive rights, it would have to be paid for, and that's turned out to be a more limited right than the Law Commission intended. But the right to compensation remains. But on what basis can the operator claim more extensive sharing rights than are provided for in paragraph 17? The reasoning we adopted in connection with the right to install equipment and the right to upgrade will not assist here, because the right to share is not a code right. Instead, the tribunal has a discretion whether or not to impose such a term, subject to the constraint of paragraph 23(5). Now, that's pretty difficult to unpick when one knows what the procedure is supposed to be under Part 5, because to start with, a distinction is being made between a code right and a term of sharing. And one's bound to ask, well, why does that make any difference when one's just considering the terms of a new agreement? As one should be, just considering the terms of a new agreement. The second thing is that they seem to have in mind that the sort of para 17 type of reasoning, or at least perhaps it's the paragraph 20 kind of reasoning, only applies where you're talking about code rights. So that where does the tribunal get its discretion from, subject to the constraint of paragraph 23(5)? This is a rather confused paragraph. What they should have observed is that Part 5 sets out the approach which the court has to make, and that is where one goes for the right information.
But just in practical terms, I mean, you've made your points, and I'm sure you'll make them again, about the importance of the existing agreement and about departure from paragraph 17, and those stand anyway. But in terms of what the tribunal is saying here, it says it has a discretion. Well, you agree with that. And you agree that there's a constraint to paragraph 23(5).
Yes, but where I part company is with the way in which that discretion and that test is then elucidated for the purpose of the judgment. Because if you go on to 61, they make a point about 23(5), and then at the end of 23, and perhaps a better way to look at it is this, and then essentially write their own test. 62, first the tribunal should consider the term the operator seeks and the reason why it needs it in order to pursue the business for whose purposes it received Ofcom direction, and in light of the public interest in the choice of high-quality telecommunication services. Second, the tribunal will consider the concerns or objections raised by the respondent, and whether in order to minimise loss or damage in accordance with paragraph 23(5), the term should not be imposed or should be imposed to a limited or qualified extent. And if those concerns do not prevent the imposition of the term and do not require its qualification, then the tribunal will consider whether in imposing that term it should also impose further terms to minimise loss or damage. Now that is all about paragraph 20, really. That is saying I'm looking at what is wanted as my starting point. I'm not looking at paragraph 17, nor am I looking at the terms of the original agreement.
And I absolutely followed the point about paragraph 17 and the point about the original agreement. But those particular aspects of part, it's fine in paragraph 34 terms, really, isn't it? You look at what the operator is asking for, you look at whether there's a reason for that, you look at what the site provider is objecting to, and so on. You have a discretion.
Well, yes, except what's gone wrong is that the starting point in the mind of the tribunal was the public benefit test. The two conditions which is compensatable injury and public benefit, in particular public benefit test. So if you think about that as the threshold issue, then what a judge is going to have in mind is, well, you fulfilled the public benefit test. So now there's a following wind behind you for whatever it is you want. Now that's where it goes wrong. You need to haul back and say, that's all irrelevant. Public benefit is a given. What we actually need to look at is the terms of the agreement, paragraph 17, and see whether there's anything specific that needs to be changed in that context. So if I could therefore just sort of move on briefly to what should have happened, and just keep those submissions short as I can. As I've indicated, if this court takes the view that the tribunal did go wrong, proceeded on a wrong basis, then it's open to this court to send it back to the tribunal and say, think again on the right basis. And that is our secondary position, as it were. But if I could perhaps respectfully encourage your Lordship and your Ladyship to take a more hands-on approach to this to avoid further cost, what we'd say is this. There is already enough before the court to enable it to reach a conclusion, this court, to enable it to reach an accusation itself. This is principally because there's no real case that was put forward for any change to the paragraph 17 rights. The existing lease was subject to consent provisions and, in the case of sharing, a so-called pay-away clause. In other words, that was the right for the landowner to share in any extra profit that was made out of sharing the relevant equipment. Those rights as conditions and as payment clauses have gone as a result of paragraph 17. So paragraph 17 is the starting point, and our proposal was that if you've got rid of the qualified consent condition and the pay-away, it doesn't follow that that the infrastructure provider should be allowed whatever it wants in relation to upgrading and sharing. The natural conclusion is to go with paragraph 17. And the On Tower case that was put forward was to the effect that on upgrading, it needed to have maximum flexibility to meet any technological developments which may take place over the period of the new lease. And on sharing, that its business model as a so-called whip requires it to be able to share the apparatus with as many operators as it can. But that rather misses the point, because paragraph 17 already grants upgrading and sharing obligations, admittedly subject to the conditions in 2 and 3. But if those are fulfilled, then there are wide-ranging upgrading and sharing rights. And so On Tower's business has the benefit of those rights, and cannot claim that it is, to use a phrase used in the judgment, and indeed I think in the L&Q judgment, is out of business. It's not out of business, and it hasn't been out of business with limited rights for the last 20 years. So the narrow point that they must address is whether it would be right in the circumstances of this case to be allowed to make more than a minimal adverse impact on the appearance of the apparatus, or to cause loss and damage to the landowner. And what was not, neither of those issues was the subject of specific evidence. So, for example, first, there was no evidence that the appearance was irrelevant to to the landowner. And it was unlikely to be irrelevant because it's in the middle of a national park. It's not like the University of Arts building in the centre of the Elephant Castle roundabout. Appearance would be highly material to anybody interested in or visiting this site. No doubt there are planning constraints, as my Lord Justice Dingemans has pointed out, but why should the landlord be left to that protection alone? No reason was given to deny the landlord the protection afforded by paragraph 17. The second point, there was no evidence of what is likely to happen over the course of the new lease. So no information to assess was put forward. Just a general statement of being responsive to whatever might happen. No doubt flexibility as offered by an unconstrained right is good for On Tower's business. I don't dispute any of that. But that brings up the very issue discussed in May, which is that business interests of one side are not paramount, even if they are good, if there are good estate management or market reasons for changing, as in that case, a service charge provision. The question is one of essential fairness to both parties. Why should this party be allowed to inflict further prejudice, loss and damage on a landowner? And then the absence of information about what is to happen in the future, the protection needed by the site provider is greater rather than less in our submissions. The tribunal indeed accepted the site provider's evidence about the fears. I won't go back to it, but it's at the decision at paragraphs 51 to 52. They said the fears were exaggerated, but nevertheless acknowledged that these were serious concerns. And of course they are, because you just don't know what's coming. On Tower didn't then have any specific reason or evidence to allay or override those legitimate fears, nor therefore any reason or evidence to claim a right wider than the protections given by paragraph 17. And there was no evidence, specific evidence, of the effect on the business of On Tower of being subject to the paragraph 17 restraints, that is, appearance and prejudice. The historical evidence was of a harmonious relationship between the parties over 20 years or so, sharing rights being operated perfectly successfully during that time. No differences of upgrading or sharing, even though there were consent and pay-away provisions.
Can we just pause a moment? We've run on past 1 o'clock. You've got a little way still to go, have you?
Just a little way, I think.
Mr. Radley Gardner, how long are you expecting to need?
Apologies, my Lord. The slight difficulty is there is a certain amount from our learned friends' submissions that I need to unpack. In particular, I would be very anxious to ensure that the court saw certain parts of the decision below to understand what the judge and the parties thought was in dispute when they stood up at 10:30 at the trial, which I may need to take you, hopefully, as briefly but as accurately as possible through that. I think I might be an hour and a half.
Yes, I see.
I'll try and...
If an hour and a half is realistic, then I don't think we've got any particular difficulty because we can go anyway to 4:15. And I'm not anticipating that Mr. Plymouth will be many minutes beyond 2 o'clock. And ordinarily replies tend to be quite short in this court.
I'll try and wield my editor's pen on my notes.
So, Mr. Plymouth, let me just try pinning you down to a time you're going to need after 2 o'clock.
10 minutes, I hope.
10 minutes. And Mr. Radley Gardner, I think, can live with that. So we'll start again at 2 o'clock on that basis.
approved.